Uh, on behalf of BFS Legal, let me take pleasure in inviting the audience to the webinar. BFS Legal, as you are all aware, is a full-service law firm, and when we started, me and my partners in 2007, we had decided that we are not concentrating on any specific field of law. Rather, we are a full-service law firm, and we've lived up to that name uh, all this while. So, Admiralty law is something that we have dabbled in as well. I've had the chance to work with Victor Moses, Subhojit in particular, when we had to move a suit for arrest of a ship in Calcutta. We've been in touch thereafter, and we have worked together. And now through Mr. Roy, I have the pleasure of having Mr. Banerjee's audience here. And we are in fact thankful that this session, this is something that we really look forward to when we started Lex Talk Season 1. This is more of a joint learning experience, and Admiralty law being one of the subjects that is not too well known, except to a niche practice area in respect of the legal fraternity itself. So we felt that a webinar on Admiralty law would open up the stream for a lot of others to join as well. So thank you, Mr. Banerjee, for agreeing to present this talk. I pass the mic over to Subhojit. Subhojit, take over. Thanks.
Thank you so much, Bala. It has been your initiative. This webinar is essentially your initiative, but I felt encouraged participating in this the moment you dropped the idea. Victor Moses, our firm, it has been there since 1930. There has been reconstitution of partners. I have been a partner of this firm since 2014. It has had a strong admiralty practice for at least 3 decades now. And while we have been, litigating or in consultancy for the admiralty legal issues for our clients, it is always a major, initiative, a pleasure to have the nuances of the law, the insight of the law, some of the philosophies and the challenges that encircle the statutes and the principles that we work with, and to hear about them from somebody as enlightened and as expert as Mr. Banerjee, who we have here today. Mr. Banerjee needs no introduction. He is extremely renowned for his practice both in corporate law as well as in admiralty and maritime laws across India. He was called on to the Bar of England and Wales in 1994. He enrolled with the Bar Council of West Bengal in 1994 and has been in continuous and I'd say a glorious practice since then. He was designated a senior advocate in 2014, sorry, and he is one of the for any issue that comes into maritime and admiralty law. So I'd right now hand over to Mr. Banerjee to share his vision and his understanding and to enlighten us on the concept of admiralty law and with a specific key area of interest as to the challenges that the shipping industry faces and in what context the laws that we have in India today can resist the challenges or the restrictions. Mr. Banerjee.
Thank you. Good evening, all my friends and all my learned colleagues. Thank you very much, Balasubramaniam and Mr. Ray, for some glowing tributes. I don't know whether I deserve them, but anyway, since I've been given those attributes, I accept them. Today, when they told me about this subject, I readily agreed because since the time I have practiced this subject, the maritime law branch and maritime law or admiralty law, as we know, is a subject which is very close to my heart. Though I also practice in commercial laws, which means the commercial insolvency and the company law. But this is a subject which very close to my heart, as I said. and it's quite an interesting branch of law as I see it. I know today there are a lot of my learned colleagues who are already well aware of the nitty-gritties of this law as well, and some may be just getting introduced to this branch. So I should try and give you an overall, so to say, a picture of Admiralty law, the maritime law, and to give you the basic foundation of the Admiralty law system, and which I'm sure, as I find interesting, you'll also find very interesting. And then tell you about the aspect of the law as it existed up to the year 1993, when we had that celebrated case of MV Elizabeth, which I will also address a little later. And then post Elizabeth, the development of the law. And then, of course, the present act, which has been given effect to the codified law in 2018, for 1st April 2018, which has also changed the law to some extent. Now, maritime, the word, just as a little trivia, maritime actually comes from the word maritimus, which is a Latin word, and it is derived from the word mare, M-A-R-E, which is the sea. So it's really law of the sea. And Admiralty law also are considered as synonymous, in the sense of Admiralty comes from admiral, which means someone who leads the navy of a nation. So maritime law, again, is a very, very vast subject. I mean, it has a lot of aspects like collision at sea, marine insurance, salvage, gel lavage, several other topics as well. But what I intend to really get into is the aspect of the law which is procedural, which helps you in filing proceedings in a court for claims which arise out of your ships traveling, really vessels traveling. Because otherwise there are also very detailed laws which I really don't want to go into in this, at least this lecture. Now, the very concept of, no, before that, see, one has to understand how this branch of law came around. And it's very interesting because you'll find an immediate link with this branch and as to how law has developed in other fields as well. Now, foundation of any legal system is on the basis of what it recognizes as a subject and what it seeks to govern. Now, to elaborate this statement, I'll tell you, it is like, say, even 250 years back, slaves had no legal rights. They were not considered as persons. So it is only the law which started recognizing persons, or in this case, things, as having a legal personality. Now, this is the basis of not only Admiralty law, but a lot of other law as well. Like, for instance, you will see a company. What is a company? Till the 18th century, I'm sure most of you will know that till the 18th century, these corporations, companies were really given by way of a charter, so far as we are concerned, England, charter of the English, either the Queen or the King or the Parliament. Then look at a Hindu idol. That is also given a legal personality for it to act. So legal system has extended this concept of legal personality not only to national persons, but also to juristic persons. And which I said, like a company, a corporation, a state, even a state is not a juristic person. It's only because law recognizes the state as a juristic person, or your municipal corporation, it becomes a juristic person. Now, what happened is, and again we know that ships from now thousands of years really have traveled to carry on trade and to also go from port to port. Now, the ships came from different countries when obviously it was not known immediately as to who were the owners of which country were the owners of these vessels. Now, ships incurred liability, ships contracted in the sense of uh, picking up essential necessaries, what we necessaries, which are oil, bunkers, water. Ships had to be repaired in ports. So ships went on incurring liability. Now, to really take care of this problem, the law devised a system by which legal personality was conferred on ships, which means ships were now really considered as an individual corporate personality. I'm saying corporate because some cases have used the word to say it's a corporate personality. So as by imposing this corporate personality, then you could really proceed against the vessel itself, irrespective of who was the owner, where was the owner, and now also important, certain claims which arose, particularly in respect of these vessels, are or were what was treated as claims on the vessel. You'll be not surprised to know that this law really has a very ancient maritime law, has a very, very ancient origin in the sense of there were laws like the Rhodian Sea Law, which was of the Byzantine Empire in the 7th century. There were also a set of laws. Then there were the laws of the Basilica, which is 892 AD. Then Assizes of Jerusalem, again the 11th century. Then also famous were the rolls of Oleron. Now, Oleron was an island in south of France, and from which really the lot of laws of England was then taken. So these were the ancient maritime law. And then, as we know, our jurisprudence, which obviously was heavily dependent on the English Admiralty law or the English branch of the law. The English law really developed during Henry I, which was again the 11th century. And that time, the Lord High Admiral, there's a post, Lord High Admiral used to administer all the Admiralty law functions, which means whatever had to be done with vessels, ships at that time. And please also remember that those days it was a very important jurisdiction because you had spoils of war, you had price catches, which means whatever was taken over during war. So all these was then administered by the Lord High Admiral, and of course England had the equity or the common law courts. So the Admiralty courts were really separately administered. Now, there were disputes, and if you look at history, you will see there were disputes with regard to between the Lord High Admiral and the other common law courts, and for which there was an act of 1389, Admiralty Jurisdiction Act, which really curbed the powers of the Lord High Admiral. Now, so far as we are concerned in India and also England, after this 1329, the significant Admiralty Acts which came in are the Act of 1840 and 1861. Now, though they're of some vintage, but I mention it because prior to 1993, the Elizabeth case of the Honorable Supreme Court, this was really considered as the Admiralty law in India. Now, just pausing here for a moment, I was talking about this, the genesis of how Admiralty law developed. Just to a few more sentences of this, perhaps you'll also enjoy this, that the conferment of legal personality, as I said, so as to make the ship an independent juristic entity. Please keep this in mind also, because you'll see later, at present day also, this plays a very important role. So it was considered to be an independent juristic legal personality with the right to either incur liability or to also incur obligations or to fulfill obligations. And the history of this Admiralty law, you'll be surprised to know, in the recent judgment of the Honorable Supreme Court, the Ram Janmabhoomi case that is reported in 2020, Volume 1, Supreme Court Cases, page 1, there are at least 11 to 12 paragraphs which are dedicated to tracing the history of this Admiralty law in the Ram Janmabhoomi case. And that is paragraphs 117 to 127. You'll find that it traces the history, and that's how it also analyzes that this branch is also akin to imposing corporate personality on corporations, states, Hindu idol. That was really the question in the Ram Janmabhoomi case, as you are all aware. So this is where I wanted to mention this, because to show you the parallel between Admiralty law concept and all other law concept as well. It is something imposed by the system of law itself. Now, to an Admiralty lawyer, this might be something which you have always learned, yes, and an action in rem, as you know, what we call an action in rem, which is basically, in rem means a thing, and an action against a thing is what is known as an action in rem. The benefit or advantage, again, it's a Latin phrase. In rem means it's a Latin phrase, and this means that the action which you institute against the ship or the vessel really binds everyone who's interested in the vessel. So it is a right which is adjudicated so far as the property is concerned, and it will be binding on everyone having a right in that property. And that's the peculiarity of an action in rem. And mind it, this has lot of legal significance. That's how the legal system has functioned, and that is why it's called an action in rem, and it binds everyone. It is like, say, a mortgage, and that is why you see mortgages now not referred to arbitration. Why? Because arbitration is a concept of two persons, adjudication between two persons. Mortgage is not considered to be arbitrable because it adjudicates a right in respect of the property. So it's very similar to that. The vessel itself is considered to be the property, and that's why the adjudication is in respect of that property. Now, Thomas, the great author on this Admiralty maritime law, on maritime lien, had said, tracing the history, had said there are really two theories: the personification theory or the procedural theory. Now, the personification theory, he said, was where you personified the vessel as something which is a corporate entity. And procedural, he considered it as arresting the vessel or getting hold of the vessel so as to cause the owners of the vessel to come and give security. That was one of the purposes which he thought. That's how he looked at why Admiralty law developed in the first place. This is really to give effective remedy to a person who has a claim and who has dealt with a vessel. Now, law imposes this character for a purpose which it has to achieve. So the purpose by law imposed this personification theory or this corporate personality on a vessel is to achieve the purpose of having effective remedy for a person who's dealt with a vessel, because otherwise the vessel owners would not be known. So this is really the basis or the foundation on which Admiralty law or maritime law started. Now, going back to where I left off, in England, we had the Admiralty Act 1861. Now, the British had enacted the Colonial Courts of Admiralty Act 1890, which conferred jurisdiction to all their colonial courts. And that time, under the Admiralty Act 1890, there were really 6 courts in the sense of Calcutta, Madras, Bombay. There was Rangoon and Aden, which is now South Yemen, and which was part of, until 1937, it was part of British India, and the District Court of Karachi, on which they had imposed this Admiralty jurisdiction. And as you know, the High Courts of Bombay, Calcutta, Madras were all established under the latest patent 1865, which also conferred Admiralty jurisdiction on these High Courts. Then we have the Admiralty Courts India Act of 1891, which made the courts of Calcutta, Bombay and Madras exercise this Admiralty jurisdiction. And the High Courts, this is only available so far as the High Courts are concerned. And pre-independence, we also have the Government of India Act 1915, which again declared that these latest patent High Courts will be the only ones who will administer Admiralty law. So up to really till the declaration of law by the Supreme Court in 1993, in the case of Elizabeth, which I've come to it, because that's one of the, if there was a Bible in Admiralty law, before the Act came in, it was really the Bible of Admiralty law. So 1861 Act was what was applicable. The 3 courts of Bombay, Madras and Calcutta were the ones who were administering Admiralty law. And what was important, which is also surprises some non-Admiralty lawyers or people who don't really practice in this branch, that the courts, particularly Calcutta High Court, held that they had pan-India jurisdiction, which means a vessel in Gujarat could have been arrested by filing an Admiralty action for a maritime claim in Calcutta. Similarly, I think Bombay also had that view, but Madras had, if I remember correctly, had changed that view. Though now it won't be relevant by reason of the Act. So this was what was prevailing. Now, the famous case of Elizabeth, why I say is very famous, because what had happened is in 1984, the plaintiff, who was Harwan Investments, had entrusted some goods to a vessel in Marmegaon. The vessel sailed away without giving a bill of lading. Vessel went and delivered the cargo in, I think, UAE, United Arab Emirates, and then came back to Vizag. The owners of this cargo, which is Harwan Investment, then filed an Admiralty suit in the Andhra Pradesh High Court and arrested the vessel. And as happens in Admiralty matters, security was given for release of the vessel, and the suit was tried and the suit succeeded. Now, please note that up till now, we have not heard of Andhra Pradesh High Court being specifically conferred with Admiralty jurisdiction. But the point which was really taken in the Andhra Pradesh High Court was that under the 1861 Act, Admiralty Act, there was no jurisdiction in respect of outbound cargoes. Now, outbound cargoes would basically mean some cargo which is going out of India to some other country. And that is really looking at the language of the 1861 Act, because the language, if anyone ever has the time to look at the Act, you'll see it talks about goods carried into the port of England and Wales. That's the language of the Act, because we only looked at the Act. We never had an Admiralty Act for us, for ourselves, till the Admiralty Act of 2017. So that was one of the main points, and a point was also taken with regard to whether the Andhra Pradesh High Court had Admiralty jurisdiction or not. Now, this was decided by the Honorable Supreme Court in 1993. And this is what I say is the case of M.V. Elizabeth. That's reported in AIR 1993 Supreme Court 1014. I'm sorry, I always remember this citation. That's where the supplemental Supreme Court is the other citation, which I don't remember. Now, this judgment is very interesting because it was really lawmaking or case of judicial activism so far as Admiralty branch is concerned. And Justice Thomen was the Honorable Judge of the Supreme Court who dealt with the matter. And what he said is very interesting because what he did, he analyzed the provisions of the 1890-1891 Colonial Courts of Admiralty Act. He looked at the 1861 Act of England and he said that the law was not, Admiralty law did not stop growing or was not confined to the Admiralty Act 1861. He said what the Colonial Courts of Admiralty Act did was to vest the Admiralty courts in India of the jurisdiction which was then prevailing in the English courts. Just see, I'm sorry, we have a cyclone brewing here, so sometimes the lights are, the electricity is trying to play. I'm sorry about that, but unfortunately, this part of India and Calcutta, we have a very bad or a severe cyclone going through. Anyway, so coming back to matters of sea, to just ignore the cyclone for a little while. Oops. So coming back to the 1993 Supreme Court. So what the Supreme Court did, it equated the Indian Admiralty courts to that of the English Admiralty courts and said that India must recognize in the absence of an Admiralty Act here, in the absence of an Admiralty Act, and they had said that you must have an Admiralty Act immediately in 1993, which finally fructified in 2017. But they said in the absence of an Admiralty Act here, the Indian Admiralty courts are really to administer, is to equate it and say that Indian Admiralty Court should also administer the English law which is then prevailing. So by this, the Supreme Court considered that you must consider in England those days, the act which looked at the Admiralty branch was the Administration of Justices Act 1956, the Supreme Court Act 1981, which was based on the Brussels Conventions, I think, and the Civil Jurisdiction and Judgments Act 1982. And it equated and also said another very important and interesting thing. It said Andhra Pradesh High Court, being a successor of the Madras High Court, it inherited the Admiralty jurisdiction. So Admiralty jurisdiction was given to one of the coastal states, and this is really by judicial activism. And if you look at AIR 1993 Supreme Court 104, it's a tremendous exposition of the Admiralty law development as well as how it stood as on that date. Even the Anglo-American law is the American law is also that they also institute actions in rem against vessels, and but this is actually unknown to the civil law system. The civil law, the Roman law system, I think they have a system by which they also arrest vessels, but it was really an action in personnel, and they also have jurisdiction by presence of the vessel within the territorial waters. Now, Again, the logic is very simple, saying that when you enter territorial waters of a country, you subject yourself to the laws of that country. And apart from this Admiralty law, of course, we have the Merchant Shipping Act of 1958, which has extensive provisions. In fact, the Supreme Court in Elizabeth also considered Section 443 and 444 of the Merchant Shipping Act, which also gives powers of arrest, powers to detain vessels. Now, the Merchant Shipping Act is, as many of you would know, is of it's regulating the shipping industry, merchant ships, its safety of life and property. It establishes, I think, the National Shipping Board, registration of merchant shipping classification. So that's another arena where you have to really detailed studying or detailed work has to be looked at when you look at the Merchant Shipping Act, the other. Now, so Elizabeth is what really expanded the scope of the Admiralty law in India. And then we could look at the international law, so to say, English law, as well as what was being applied in England, to adjudicate Admiralty matters, to determine Admiralty matters in India. So that's what 1993 Supreme Court did. Another case which is also very important is the case of MB Sea Success, which was reported in 2004, 9 Supreme Court cases 512. And again, you'll see after really another 10 years, that Supreme Court again said that we don't have a Admiralty Act and we should have an Admiralty Act. And here the issue was whether unpaid insurance premiums for ships are necessaries or not, and therefore whether they were maritime claim. And again, the Honorable Supreme Court, really following Elizabeth and expanding it further, they said that there was an Arrest Convention of 1999, which is the International Convention of Arrest 1999. They said that even this is a part of Indian law. So again, expansion of the Admiralty law. To say you look at the general international body of Admiralty law, and that is what will be administered by our Admiralty courts in India. So you see a development from, now giving you the basis why Admiralty law really came about, or the Maritime Law branch came about. Then you have seen 1861. In India, we followed the English Act from 1861, which was made applicable to India by our acts, right up to 1993. 1993 expanded the Admiralty law to say that it should be akin to what is being administered in the English Admiralty courts. Then then MB Success again expanded further and said that now you look at the international convention or international law to see what would be the maritime law in India. Now, two sub-subjects really, or two important topics in Admiralty law, and which is what there is in the concept of Admiralty law. There is something which is a maritime claim, and within maritime claim is something which is called maritime lien. Now, the difference is of utmost importance because maritime liens are a very special sort of claims, and I think there's some case also referred to as sui generis claims, which attaches to a vessel irrespective of its change of ownership. So if a vessel was sold, then also maritime lien and maritime lien were considered as subjects like seaman's wages, master's disbursements, then your salvage, and some of the specialized claims, port charges. Now, the superset, which included those maritime liens. Maritime claims are something which was like damage done to your goods on board a vessel. So these are maritime claims, which are really statutory claims. Now, this was actually quite well explained in one of the by Justice Nariman in one of the in a Supreme Court, obviously Supreme Court judgment. This is the Chrysomar Corporation, MGR Steels, and this is reported in 2018, 16 Supreme Court cases, 117. Now, I also refer to this judgment because at that time when it was decided, I think it was March of 2018, if I'm not, the Admiralty Act had not been given effect to, because it was given effect to on 1st April 2018. He again reiterated and said that 99 Arrest Convention was part of Indian domestic admiralty law. This has a significance. I'll tie it in the end when I explain to you the present act. So, but here he explained in great detail and with lot of depth on the question of what is a maritime lien and what is a maritime claim, as well as whether necessaries. Necessaries means goods which I said are supplied to vessels like fuel oil, water, which are supplied to the. So he said necessaries also are not maritime liens. Because of the controversy, I think Calcutta High Court had held that necessaries are not maritime lien, followed the Calcutta High Court decision and said. And there's a difference. American law hold or have held that necessaries are maritime liens. So he also clarified that. And there's also another judgment during that time, and these are all prior to the coming into effect of the Admiralty Act, is the Geo Commander, which went into a question whether a demised charterer was considered to be an owner of the vessel or not. You also know there vessels are chartered. There are really three kinds of charter party. It's a demised charter, a bareboat charter party, or a time charter, or a void charter. So, an demised or bareboat charter is when you get the vessel without the master. It's really you become the temporary owner for that particular period. It's bareboat. And the others, as the name says, time charter and void charter is for a particular voyage or a particular time period of which. Now, again, this charter party aspect, disputes with regard to charter parties, it's a tremendous area, and it's a very vast area which has a lot of very, let me put it this way, detailed laws, which I'm again not going into. This is just to give you a general idea as to why that charter parties are used to define really when you take on hire a vessel. So this was the position of law. There was also another aspect which, prior to coming into this new act, the Admiralty Act, whether Indian vessels could be arrested or not. Now, the Calcutta view just prior to the act was that vessels which are owned by Indian companies cannot be arrested. Whereas other views, Bombay, I think, held at that time that Indian vessels could be arrested. So this was the situation in which the Admiralty Act was enacted. This is the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. This is what the Supreme Court has been asking for since 1993, but finally it came. And I have a colleague and a friend who was, of course, also part of this framing of the act and the section. So anything which goes wrong, I generally pick on him to make comments on the act. So, so this, and I just want to read the preamble of the act because this is very important. Again, I'll tell you why. It says, an act to consolidate the laws relating to Admiralty jurisdiction, legal proceedings in connection with vessels, their arrest, detention, sale, and other matters connected therewith or incidental thereto. and it repeals at section 17, it repeals the application in India of the following enactments are hereby repealed: the Admiralty Court Act 1840, the Admiralty Court Act 1861, the Colonial Courts of Admiralty Act 1890, Colonial Courts of Admiralty India Act 1891, and the provisions of the latest patent in 1865, insofar as they apply to the Admiralty jurisdiction of the Bombay, Calcutta, and Madras High Court. Now, this means that logically, this is the act which we should look at for the purpose of administering Admiralty law. Now, logically, this is what I would have thought, but there are already judgments which says, no, I'm sorry, apart from the Admiralty Act, it is not a complete code, and apart from the Admiralty Act, we can still continue to look at the other Admiralty law or international law which is existing, which I find a little, let me put this, I don't know whether this is logical, because this is what I will be describing as one of the challenges which we now face with regard to interpretation of the Admiralty Act itself. So, just to quickly take you through the present scheme of the Admiralty Act. So, that is what the preamble said. It was an act to consolidate. First, section 1, subsection 2, it is to apply to all vessels, irrespective of places of residence or domicile of the owner, which means Indian vessels could also be arrested by an Admiralty court. Then it is not to apply to warships, naval auxiliary, that is all right. Now, the very important change it made several important changes, is conferring Admiralty jurisdiction. What it says in section 2, subsection E, it defines High Court. And it says High Court in relation to an Admiralty proceeding means any of the High Courts of Calcutta, Bombay, Madras, Karnataka, Gujarat, Orissa, Kerala, and High Court of Judicature, Hyderabad for the state of Telangana and the state of Andhra Pradesh, or any other High Court as may be notified. So, it takes away really the so-called monopoly of the Calcutta, Madras and Bombay High Courts, and it confers Admiralty jurisdiction on all the coastal High Courts, really, so whoever has a coast. And I really think this was a welcome which was really needed, because it will then be the High Courts of that particular state will be administering and looking after matters which arise out of their jurisdiction, their courts which are. Now, maritime claims are defined in section 4. Maritime claims are also given in section 9. The jurisdiction, section 3, I just want to read quickly, subject to the provision section 4, jurisdiction in respect of all maritime claims under this act shall vest in the respective high courts and be exercised over the waters up to and including the territorial waters of their respective jurisdictions in accordance with the provisions contained in the act. So the high courts, though there is no concept of a state having an exclusive, in that sense, access to the territorial waters, but anyway, it says that the territorial waters of that particular state will really be the jurisdiction of the High Court. Now, maritime claim is defined in section 4 of the Act, and it has all the international, if I may put it this way, in consonance with or at par with whatever the Arrest Convention of 99 or the other international branch of Admiralty law had said with regard to claims. It has disputes. I'm just reading a few. Section 4.1a is like disputes regarding the possession or ownership of a vessel. Then H is agreement relating to use or hire of the vessel. Then D is loss or damage caused by the operation of the vessel. Then F is loss or damage to or connection with any goods, which is really the most common ones which we use for the purpose of claiming, making claims for damages done to goods which are carried on board a vessel. Then you have section 4(1)(w) is maritime lien. And section 4, subsection 4 is, I'm referring to this because now it has become important. Subsection 4 says any vessel ordered to be arrested or any proceeds of a vessel on sale under this act shall be held as security against any claim pending final outcome of the Admiralty proceeding. Now, I read out this section 4(4), to tell you a very important aspect of the law which has now arisen by reason of insolvency and company cases. That's why I read out section 4(4). Then section 5 is with regard to arrest of the vessel. Section 5(2) also permits arrest of a sister ship. Now, that's also another concept in maritime law by which you can arrest the vessel owned by the another vessel owned by the person against whom you have a maritime claim. So basically, the offending vessel, which means the vessel which has caused you damage, and the other vessel have to have same owners really. So that is the concept of a sister ship, very loosely. That is very loosely. There are also a lot of details with regard to that, but section 5 subsection 2 preserves that right. Then section 6 and 7 is it's a formalized. It's a section. Sections formalizes really a concept which is known as that. Since I told you earlier that Admiralty action is generally an action in rem, you can also have an action in personam, which means for a maritime claim, you can also exercise Admiralty jurisdiction by action in personam against the owner. And the jurisdiction clause is given. Section 8 is an extremely important section under the Admiralty Act. It provides that on the sale of a vessel under this act by the High Court, in exercise of its Admiralty jurisdiction, the vessel shall stand. The vessel shall vest in the purchaser, free from all encumbrances, liens, attachments, registered mortgages, and charges of the same nature on the vessel. So this means that when a vessel is sold under the Admiralty jurisdiction, it goes encumbrance free, and this is a very important right, because that is why one would prefer buying a vessel in an Admiralty sale than, because you can also have a civil suit. You can attach a vessel as a property of an owner and you can sell it, but that doesn't give it encumbrance free. So here it is statutorily section 8 gives you encumbrance free, and as you know, a court sale doesn't mean that it takes away all other claimants. If there's a higher claimant, then that continues even after the sale. Section 9 is the maritime lien section, and it defines what is a maritime lien. I have already told you maritime lien is something which travels with the vessel irrespective of change of ownership, which means it attaches the vessel. And in fact, some books of history of Admiralty law says that maritime liens were really the first sort of maritime claims to be recognized, and then the statutory maritime claims came. But the maritime liens are really the forefathers of the claims which was pursued in Admiralty matters. I'm sorry again, but this is a lot of cyclone weather, and so maritime lien. I'll just give you read out some of the sections. Section 9(1)(a) says claim for wages and other sums due to masters, officers, other members. Then B, claims in respect of loss of life or personal injury. Then C is claims for reward for salvage. D is claims for port, canal, and other statutory dues. Then claims caused by the damage by the vessel itself. So these are the types of claims which are the maritime lien which travels with the vessel. Section 9(2) is extremely important. Otherwise, see, maritime, what it does, the maritime lien specified, this is what it says, section 9, subsection 2, maritime lien specified in subsection 1 shall continue to exist on the vessel, notwithstanding any change of ownership or registration, and shall be extinguished after period of expiry of a period of 1 year, unless prior to expiry you have arrested the vessel. So, the purchaser of a vessel is also protected that if a maritime lien claimant does not pursue his claim for more than a year, then that lien goes. Now, before this act, I would imagine that the law would have been that if, say, in India, the limitation is for 3 years. So, if you had not pursued a claim for 3 years, it would have been barred. But this act specifically says if you don't pursue it for 1 year, this gets barred. And so far as there's a proviso which provides a limitation for 2 years for which wage sums cost of repatriation social insurance contribution falls due. So this is another sort of case. So 1 year and 2 years. This is under section 9. Section 10 gives you priority of maritime claim. Section 11 is what we used to have in common law, that whoever arrested a vessel, suppose you have a claim, you went and arrested a vessel, then the court would have asked you that if it is a wrongful arrest, you have to give an undertaking in damages, which means that whatever damages the owner would suffer, because you understand that if you detain a vessel in a port, there are several other expenses. You port charges you will incur. You might fail your next commitment because the vessel will have to travel from port to port. It is a commercial venture which the vessel has to undertake. So now, section 11 gives a statutory recognition. So you have to give an undertaking as a condition of arrest of a vessel that you will be liable for the damages. Then section 12 is the appeal provision. Sorry, section 14 is the appeal provision. And section 16 is a power making rule. And I think for so far as the all of the Admiralty law is concerned, I think Calcutta just framed a rule. I don't think it has been notified yet, but Calcutta has framed. I think other high courts are also framing or have framed rules. And section 7 is a very short act. Section 17, I've already told you, to the Repeal and Savings Act. Now, so this is the act now which is supposed to deal with the Admiralty law in India. Except for two things now. Remember, I mentioned to you the Chrisomar Corporation case of the Supreme Court Justice Nariman. Justice Nariman had, at that time, this act had not been given effect to, but the Justice Nariman considered the act in the sense of notice that the act was already been gazetted but not been notified. But he still said that the 99 Arrest Convention was part of the Admiralty law in India. Now, this means that we are not only to look at the Admiralty Act, but we can also look at other things. And which again, in my mind, is really again opening the branch very extensively without any boundaries. I thought this is what the Admiralty Act really wanted to address. And I also find a judgment of the Bombay High Court, and this is some of you will also, I'm sure, the Bombay lawyers, if they have joined, will know this is the Altus Uber matter. This is a division bench of Justice Dharmadhikari, reported in 2019 SCC Online Bombay 1327. This is 2019 SCC Online Bombay 1327. This was on the issue of whether even after institution of arbitration proceedings, whether you could institute an Admiralty suit or not. I think that was the issue which was being discussed, and whether court still had the power of arrest. Now, so far that is concerned, I have no difficulty in saying the court had power of arrest for a maritime claim. That was one of the logic. But in paragraph 66 and 67, what I find is what the division bench of the Bombay High Court really held that, and I want to read a few lines. The Admiralty Act 27 is special act. However, it is not a self-contained code, unlike the Arbitration and Conciliation Act 1996. There are several other statutes which deal with arrest and detention of ships and maritime claims. Understandable. Merchant Shipping Act, Indian Ports Act, such. Observation Balco, such. And then it says that you can also look at other aspects of the Admiralty law to see whether power is there of the Admiralty Court or not. And they came to a conclusion that it says, paragraph 68 of the judgment says, no statute caters to every fact situation. The submission that what is not provided of is impliedly excluded is not correct. Then again repeats, Admiralty Act 27, not a self-contained court. So I think this widens the jurisdiction of the Admiralty courts again, and it refers to sea success and also refers to the presumer somewhere. So this is one of the, if you have to look at the present challenges, this is one of the present challenges in the sense of whether again we are going into a wider definition of or sort of a rather wider branch of law which is wider than the Admiralty Act or not. That is something which one has to now consider. Now the other aspect which is very interesting and which is very challenging is with regard to the question as to now Indian vessels can also be arrested under the Admiralty Act. What happens if the corporation which owns the vessel, the Indian company, goes into liquidation or goes into insolvency? I'll tell you why the difficulty arises, because as you know, under the Companies Act, there is a particular method or there is a particular manner in which if a company goes into liquidation, the company's assets are to be distributed. The insolvency laws also has a particular manner of distribution, which is now different than the manner of distribution which is given in section 9 of the Admiralty Act and section 10 of the Admiralty Act. Now the question will immediately arise, which will prevail? Whether the Admiralty Act will prevail or whether the Companies Act distribution will prevail. Now you also know under the Companies Act, if a company goes into liquidation, then any proceedings against that company can be proceeded with only with leave of the official liquidator. And in the Insolvency Code, section 14, there is a moratorium under by which no proceedings can go on against a company which is in insolvency. Now, since I practice in both branches, as an insolvency lawyer, my opinion really would have been that the Insolvency Code has to prevail because it has a non-obstante clause on section 238, but the Admiralty Act does not have a non-obstante clause. But as a maritime lawyer, and which I think heart of hearts I'm more of a maritime lawyer, the Admiralty Act has to prevail because it is also a special act and it is to really look after claims in respect of a vessel, and which are different sorts of claims, which are different than claims as we understand in the company liquidation jurisdiction, because these are specialized claims. In so far as the Companies Act, leave under Companies Act is concerned, and there's a Madras High Court division bench where I had the privilege of appearing. This is Pratibha Shipping versus Praxis. It is reported in 2019, 6 Madras Law Journal, page 385. And it held that you do not need leave under the Companies Act because to proceed against, to proceed in respect of a Admiralty suit. And the logic which was used was saying that it is really against the vessel and it is not against the company in liquidation, and both being special act and the Admiralty Act being a latter special act, and that is, as you know, interpretation of statutes and all that will come in. You would not, and the Madras High Court also agreed, that the division bench agreed. So, as I was on the Madras High Court decision, and the Madras High Court held that you don't need to take leave. As I was saying, you don't need to take leave under the Companies Act, and the logic being that it is not against the company, the corporation, it is really against the vessel. Now see how this concept, the foundation of Admiralty law, that the vessel is a different corporate personality, is really being used to get away from this difficulty. And this is an action in rem, which means an action against the property. So the logic, the Madras High Court unfortunately could have expanded more, but it just said it's a special act and distinguished it on that basis, saying that since the ship has, the vessel has a different personality, the corporate personality, and the company is, the owner is a separate entity, the Admiralty action could have proceeded and no leave was required. And it agreed with this a single bench decision of the Madras High Court, but the Bombay High Court so just to now this judgment of Justice Shriram, now he considered both aspects, because in the Madras High Court the only aspect which was being considered was Admiralty Act vis-a-vis the Companies Act. But Justice Shriram considered both Admiralty Act because the issues were both under the Companies Act and under the IBC. The Companies Act, he had agreed with the Madras High Court division bench, but he said for different reasons. He said, I want to give my own reasons for that. But what is interesting is this fight between the IBC, the Insolvency and Bankruptcy Court, and the Admiralty action. Because section 14 of the IBC gives a absolute bar, and the Supreme Court in one of the judgments in IBC matters have held that you can't even proceed in arbitration. Justice Shriram, what he did, he said that you have to give a very purposive interpretation to both the acts. He understood the difficulty because IBC has a non-obstante clause, which means it will take effect irrespective of anything, any other proceedings and any other law. That's section 238. The Admiralty Act doesn't have a non-obstante clause. So, according to interpretation of statute, according to interpretation of the statute, I just had a note. It's the MV Malavia, which has just been delivered today, 19 May 2020. Today has been, I think, yesterday it was, the judgment was given of Justice Shriram. So, what he did, he said that since the law is that you have to give preference to a special law which has a non-obstante clause over the Admiralty Act, if there is any contradiction, he held that there is no contradiction. He said they are all, it can be harmoniously given a construction. And the harmonious construction is that in Admiralty law, you proceed against the vessel, which is a corporate personality. So, really, the genesis being drawn is right from the inception of Admiralty law. So, he says it's a Corporate personality, it's a separate entity. The owner is a separate entity which is under IBC. And in spite of the non-obstante clause, you should proceed. You can proceed in Admiralty action. You can file an Admiralty action. But of course, he had a caveat here. He said that if a Admiralty action is pending and a company goes into insolvency, then the Section 14 moratorium will apply, which means that you can't proceed with the Admiralty action. But even if IBC Section 14 is there in insolvency proceeding the pending, you can institute a suit, arrest the vessel, but you cannot proceed. After liquidation, the Admiralty court will sell it and the proceeds will be given, kept as a security. He used this concept, and that's why I had told you about Section 4.4 of the Admiralty Act, and which says it is kept as a security. So he said that even if the vessel is sold, the sale proceeds are kept as a security for the Admiralty claimants. Now, this is very interesting, and it's definitely a forward-looking judgment, but there will be a lot of difficulties on this, because I don't think it can be interpreted as simply as as the Bombay High Court has put it, because there will be claimants when the bank may be a claimant. What happens, and which is a question which I really give to you, you might think about this. What happens if an Admiralty claimant is also included in a resolution plan? Does he lose his claim? Now, all these aspects will have to be considered. I don't think the judgment had that scope to explain it as well, but those are issues which one really needs to consider. So I just want to, from this judgment of MB Malaviya, I'm sorry, it's an unreported judgment which I was sent, and it's not, I don't think it's in the SCC online as yet. It says at paragraph 46, he says, since the vessel is a corporate person, that is why action in Admiralty can proceed, and he also holds that the plaintiff in an Admiralty action is a secured creditor in respect of the vessel. His conclusions were that the Admiralty suit can be filed when Section 14 IBC is there, which I just mentioned, but cannot be proceeded with. And he also said the priorities will be in accordance with the Admiralty Act, which is what I was worried about, because I want that to be done, because the Admiralty claimants will quite naturally be different, or would have a different priority than people who will claim in insolvency or in winding up. He also holds, which I earlier said, he also holds that you don't need to have any leave from the Companies Act, because Companies Act there won't be much difficulty, because though Companies Act is also a specialized act, but then it is a prior act and it doesn't have a non-obstante clause. So Companies Act, Admiralty Act controversy, I don't see any difficulty on that. So kindly see, as a result of what has happened, the Admiralty Act and this particular method of distribution in the Admiralty Act, we have created another court for distribution of assets insofar as an insolvent company is concerned. So this is what has been done as a result of this particular interaction between the insolvent companies and an Admiralty action. The only other aspect is Chartabadi, I have said. The other aspect which I've also explained is on the question of whether Admiralty Act is the only branch, only whether that's the only provision we look at for the purpose of interpreting the Admiralty law in India. It seems already cases have made inroads into it. The Bombay High Court division bench, which I mentioned, that was the case which I've already referred to, that 2019 SCC Online Bombay 1327. But I have one particular question again to you, that how Elizabeth and C. Success looked at it is by saying the Admiralty Act 1890 and 1891 equated our Admiralty courts to the English courts. That is why we have to look at the international law. That is why we have to look at the other aspects of law. But it seems now, in spite of our own Admiralty Act 2017, the courts still want to look into other international conventions. So anyway, those are what I wanted to say on this Admiralty law. Thank you very much.
May I just thank Mr. Banerjee on behalf of all in attendance. The cyclone is extremely severe over Calcutta and South Bengal right now, and I can only thank Mr. Banerjee for presenting his this so interesting lecture, even with the troubles that we are having with the electricity and with the network becoming very, very difficult right now. But I really thank Mr. Banerjee. It was
Thank you very much.
Extremely insightful. It was extremely insightful.
Thank you. I'm really sorry about this little disturbances, but we have chosen a day when there is a lot of storm in the sea. Thank
Bala,
you.
Bala, you are not audible. Yes.
Yes. Thank you very much, Mr. Banerjee. I mean, I can imagine the pains that you have taken amidst, as you say, the storm, the sea, and maintaining the calm. Thank you very much. We are all very much enlightened, and we are happy that the session still went through despite all the difficulties.
It did, and I must also say, I cannot thank Mr. Banerjee enough because we are getting some wonderful feedbacks on his lecture.
Thank you. Always glad to be of some assistance to someone. Thank you very much.
Thank you so much.
Thank you very much. Thank you.
Thank you.
Thank you all.
Thank you for everyone in attendance also. I must thank everybody for
Yes, thank you very much for everyone who braved everything to be here.
Yes.
Thank you. Bye.
Thank you.